All right, good afternoon, everybody, and welcome to our Ask the Attorney panel. So before we go ahead and get started, just a couple announcements. We're going to go ahead and start today's session off with our sponsor, and we want to thank Patten, Ebling for being here and doing that today. You guys are also lucky enough to have her on our panel today. So I'm going to go ahead and welcome up Miss Mallory, and I will let everybody know in the classroom, if you are here, Mallory is doing a giveaway in the back for a $25 gift card to Starbucks. So if you have your business card, not partner, you have your business card, you'll want to pop that in the bowl. So, all right, Mallory.
Okay. All right. Hi, I'm Mallory Morretti. I'm an attorney with Patten, Ebling. For those of you who have not had the opportunity to work with our firm, we are a full service law firm. We primarily handle real estate transactions. However, we do have a trust and estates department and a business entities department as well. So we can help with any conveyance or probate, or if you need to set up a PLLC, you can reach out to me and we can have our business entities department assist with that. We also have 5 offices. We have Sarasota, Lakewood Ranch, Tampa, St. Pete, and Venice. So if you have any properties closing in those areas, whether or not your attorney works in said office, you can close at any of our other offices, and our attorneys, for a good team, we work and try to make everything as smooth as possible. Yep, so I'm also on the panel today. So I don't know if we're going to start that. I don't need to double introduce myself, but I will go grab the gift cards and we can, or business cards, and I'll pick who's the winner. So I'm going to get up and do that real quick.
There you go.
Exactly, right? All right, Lisa, you win.
I was like, I need it.
All right. For listening.
There you go. Cool.
All right, so then I think we're just going to go ahead and get started with the presentation. We did create a little handout. If anybody didn't grab one, it's in the back. It's something that if you're working with a buyer, you might want to provide to your buyer to kind of have them address any considerations that they might have moving forward with new consideration or with new construction. So that's something more of just kind of an overview of everything we're going to go over today, and then you can provide it to your clients if you're working with them with new construction, so that they know what they're getting into and can ask any questions to either you, or you can put them in touch with myself or any other attorney. So, want to introduce yourself?
Sure. My name is Gregg. I'm with Premier Sothebys, but I sell exclusively Beso, which is a luxury condo building in the Quay in downtown Sarasota, right there on the corner of Fruitville and 41. We're under construction. We still have a few condos left. So if any of you who are present or watching online, you can get a hold of us. My email address is Gregg, Gregg @beso.com, BAYSO. You can see us also at beso.com, and it's really a great website for a lot of the information. So yeah, that's it.
Okay, and then we're.
Do you want to let them know, I'm putting it in the chat? I'll put your information in the chat. They can't hear me back here, so we just let them know.
Okay, our information will be in the chat there.
Yeah. So if you want to reach out to either one of us, you can do so via email, and our information will be in that chat. So we're just going to kind of start discussing new construction, and there's differences in obviously the standard contracts that builders use. And I think the most typical question that I get asked whenever I'm working with a buyer or even an agent is every builder contract the same? Do they use a standard contract, like there's an as-is and a standard that's typically used in Sarasota Manatee? The answer to that is no. Every builder has their own contract. Typically, the builder's attorney drafts that contract one-sided towards them. That's what they pay their attorneys the big bucks for, is to draft those contracts on their favor. That being said, some things are meant to be in there statutorily. So a lot of those contracts do have the same information, but they're all a little bit different. So if you're working with a buyer who's purchasing with John Cannon, and then the next buyer is purchasing with Beso, you're not going to know if it's the same thing. You need to either reach out to an attorney or make sure you have a really good sales rep that you're working with there so they can help navigate you through the differences of that contract. So Greg's going to talk a little bit about the differences of new construction with condominiums and new construction with single family homes, because there's differences in that as well.
Mm-hmm. And I will say that those contracts for the developer or the builder, those contracts do go through a check system up in Tallahassee. They have to get approved before they can be sent out. So there are some protections in there for the buyer, but it doesn't read very protective. It reads like it's all for the seller, but there are kind of between the lines.
Yeah.
Would you say there's some there are protections for the buyer that's in there. I do want to talk about difference when purchasing a single family home and in new construction versus resale. And those single family homes could also be a condominium. The condos don't have a draw schedule, but the single family homes do. And what I mean by a draw schedule is that if you're building a single family home, you're going to go out and get a loan from a lender, and they'll set that money aside, and the general contractor will then have to reach certain points in the construction in order to get more money for the next section of building. While in condos, you put in a deposit and the developer will use that deposit to build with, and that deposit can be anywhere between 20 and 30%. So, but they are going to use that money for construction. That first 10% though of that deposit is secured, and it will be held in an escrow account until that builder may or may not withdraw that after obtaining a security bond to protect that, which is actually safer than an escrow account, that security bond. And the rest of that money, though, is going to be used for construction. But that's the difference in that draw schedule versus that deposit schedule in single family home and condos. Now, another thing that condos don't have versus the single family homes are what are called change orders. A change order is what we call in the condo business, maybe an upgrade. It's the selections process. When your buyer goes to a single family home or a condo and they select the house that they want to build, they will be sent to a design center or a selection center. And some builders do, they let you pick and choose all sorts of levels of flooring and cabinets and sinks, so you name it. They'll let you pick just anything out of their design center, while other builders may have just a grouping. So there's one particular builder that has an A, a B, a C, and a D, and you pick one of those, and there'll be certain colors and level of quality. So those are some differences there. Now in condos, if you're not doing a custom condo, there will be some selections where you select the colors, you select the color of flooring, the tile, the cabinets, your quartz countertops, but there are very few things to choose from there. Now, the advantage of having one of those, like an advantage of being able to go in and have those selections is that you get your, and this is versus resale. In new construction, you can go in and pick out your colors, you can pick out your finishes and all of that, and you get pretty much exactly what you want, almost. But in resale, to get exactly what you want, you're going to have to gut it and put in all that work yourself. So it's the advantage of new construction is you get exactly what you want versus having to maybe upgrade your new purchase in a resale. But buying that new home, that new single home, could actually increase that purchase price by up to 33%. When you get into some of those selections on those custom homes. But it's good for the buyer. I will say though that 99% of the time for you as an agent, when you go into a single family home or a condo, you're only going to get paid a commission on the base purchase of land and home and not on any of the upgrades. So know that going in. Don't get disappointed that you're not going to get that 33% kick up in commission payment, because you're only going to get paid on the base of that model of that home and possibly the land. All right, so Mallory can explain to us how that deposit and schedule works in new contracts.
Yeah, so Greg touched upon it in regards to the 10% with condos. With that, everything is statutory with a condo declaration, rules and regs. All of those have to go in accordance with the Florida statutes and in turn Florida admin code. So it's very conspicuous on any condominium contract that has this 10% access or excess that the developer can use for construction. It says at the very top of the contract, and it statutorily has to, and then it's also right above where the buyer is signing. So the exact words, just for you guys to know, it's going to be in boldface, conspicuous typing. It's going to state any payment in excess of 10% of the purchase price made to the developer prior to closing pursuant to this contract may be used for construction purposes by the developer. And that's putting the buyers on notice that when they make their initial 10% deposit, because that's standard, is they usually make a 10% deposit. Any additional deposit after that is going to be used, if that verbiage is there, towards construction and the development. That money cannot be used for any sort of commission or salaries to the marketing department or advertising. It's solely used for the unit that they're purchasing, that condo build out, to be using that, as opposed to single family, like Greg mentioned, has that draw schedule. So if you, and they're usually like at a 20, 40, 60, 80%. So when 20% of the work is completed, that's when you pay that 20%. In a condominium, you're usually putting up that excess of 10% and they're using those funds right away. Well, when construction happens, they're not allowed to start using that either until the construction occurs, because that's what that money is for. If that makes sense. Any questions on that?
Is it basically saying that it's only actually used towards that contract's construction, or just general?
To the general development. And then another big draw with, with new construction is the warranties. Greg's going to touch on those, but those are huge advantages to buyers when purchasing new construction.
Right. So when your buyers purchase new construction, the structure of that house is going to be under a 1-year warranty, and condo as well. So that 1-year warranty is going to cover things that aren't normal wear and tear. Say a tile comes loose. It's some sort of construction process that may have some iniquities to it. There's also for condos, there's a 3-year warranty on the building itself, outside of wear and tear. And the third warranty that's in there is a 10-year latent warranty, meaning things that cannot be seen within the building. And if anything happens with those warranties, there's a peace of mind that your customer has, that the buyer has, that, hey, they'll come in and fix this short of wear and tear. It's not like when you move your furniture in, you scratch the wall, that's wear and tear. But when you first take it over and there's a big dent in the drywall, they'll come in and fix that, and that's at no cost. So
do those warranties generally transfer? So if, for example, a person buys the lot and owns the home during the construction of the home, never lives in it, and then goes to sell it, does that home warranty transfer to the new buyers, or is that generally non-transferable?
that's a good question.
Does it depend on the
Sometimes
contractor?
it will depend on the contractor. Some people will go ahead and do that. And Mallory, do you have anything
So
to
I've
say
seen
about
this
that?
a couple times. It's typically pretty rare for somebody to buy and then resell almost immediately after, at least especially within that 1-year warranty. I have had one builder that did transfer it. The buyer was savvy enough when they were doing their resale contract to put that in the additional terms that the contract was contingent upon the transfer of the warranty. So for that time, it was applicable. I wouldn't bet that that would happen all the time, though. I think you would have to be somewhat savvy to include that in the additional terms to make it contingent upon that transfer. But my guess is that's probably pretty rare for that to occur.
I'm actually in that particular situation. That's why I asked.
Oh.
Thank you.
Yeah. Hopefully that was helpful a little bit.
So there is a statute for condos that details the warranties, section 718.203 in the Florida statute section. They are required to have those warranties in them. But it's a peace of mind for your customer that if there are issues with that build out, not only for the condo but the building itself, and then the latent, meaning you can't see it, that they're all protected. When you go into resale, those warranties most likely and probably 99% of the time will not transfer over. So Mallory can explain to you how an attorney can be involved in the new construction process.
Yeah. So there's
Really quick. So, like I said, they can't hear like the audience. So if somebody asks something, can you repeat it? So whatever question that was, they're just asking you to repeat.
the question was, are warranties transferred in resale? So if that 1 year period had not expired, would a potential new buyer be able to assume or have that warranty transferred to them? All right, and then in regards to how an attorney plays a role in new construction, there's 3 ways. And before I get into the ways that an attorney can kind of factor into new construction, most builders have their own title companies specific for that project or that said development. So a lot of builders will incentivize that buyer to close with that title company, maybe by way of credit or something like that. And most of the time, that's fine. But for a lot of these projects, they're very expensive. They're massive investments to people. They want to have somebody, usually it's an attorney, kind of either give them peace of mind or walk them through it. So 3 ways that an attorney can be involved in new construction is 1, just reviewing the contract on an hourly basis. You know, you have a somewhat savvy buyer who's bought and sold before. They might just want to talk to an attorney. Hey, can you look at this contract, see if anything glaring stands out? And then that's it. They close with the builder's title company. That's all the involvement is. Or we can do what's called a buyer representation, where we actually represent the buyer's interest throughout closing. That's from prior to execution of that contract, walking them through everything, reviewing those closing documents, and getting them the new keys to their new investment. Or we can actually handle the closing. And sometimes some development companies will really try to avoid that because they're doing this. They maybe have 50, 60 homes. So they're like, we know what we're doing. We just want to handle it. So buyer representation probably occurs the most with new construction, but there are one-off times where we are just handling the closing, working with the builder's title company on the other side. But the whole point of that is that the buyer wants some sort of representation. The development company has their own title company that's representing them. So at the end of the day, if something goes wrong, they're probably not going to bring it up to the buyer. So that's something that we do in order to ensure that the buyer is safe and comfortable with their investment choices that they're making. Anything to share with that?
I was going to say that not all attorneys are the same. There are some out there that are better than others. So, do your due diligence when you're picking an attorney or suggesting an attorney for your customers.
He's not referring to me. I'm a great one.
I'm kidding. She's great. We've done a number of contracts with Mallory.
Yeah. So, and then in regards to contract review, obviously that's just me maybe speaking to the buyer for 1 to 2 hours, reviewing that contract, telling them this is what I'm looking for, this is what I'm seeing. If they say they're comfortable with it, they sign the contract, they move on. In regards to what an attorney representation looks like throughout everything from, signing that contract to closing, we review contracts, all related documents prior to them signing, so we can draft any amendments to said contract if the developer is allowing any of them. We can explain contract terms statutorily, what's needed, what's not needed, get them through timelines, because these contracts are dense. They're not as easy to read as the standard contract is or the as-is contract is. So unless you're looking and you know what you're looking for timelines, sometimes it can get convoluted and it's hard for buyers to pick out those deadlines of where they need to be at. We can draft legal documents to protect their interest. When there is a construction loan, we can close those construction loans in accordance, and our underwriter can get title updates to ensure that title is still clean. We can ensure lien releases are completed prior to the buyer's payment. If they're doing a draw schedule like the 20, 40, 60%, when we close construction loans, we're actually getting a title update to make sure that either the notice of commencements have been terminated for that work and any lien releases have been terminated, so that the buyer is continuing to have everything with their I's dotted and their T's crossed. And then we do represent them, again, like I said, from contract to closing. We review the survey for a vacant lot. We make sure that all of the setbacks or easements are there, make sure it's code compliant. And then we can look at the final survey as well to make sure that by accident, it's not platted into something or it wasn't built an inch or two over. We work to get those issues resolved at closing so that the buyer is ensuring marketable title. We're making sure that they are getting that clean marketable title at closing.
Do you help them, let's say construction was kind of faulty during the process and that was found? What is your role in that part of it? If they said, hey, we had an inspection period and figured out that they didn't do things properly, but they hired you for buyer representation.
Yeah. So I'm going to repeat the question so they can hear it. So she was asking if for some reason they're at a second inspection or a third inspection and faulty work has been discovered, what is my role in that? My role is I can assist with that. Patten also has a litigation department, and they, fortunately for me, are right next to me, so I can go get their intel and see what they would discover. Most of the time, it's not going to be that faulty, and you just go back to the contractor and say, hey, we're not going to pay you until you fix it to bring to compliance, and they'll usually just fix it.
Okay.
You might have
And there's,
more insight.
and there's
on that.
also times, there's some contracts, for example, like the contract that I work with has something in there that the seller or the developer, the contractor has a certain period of time to correct those deficiencies. So that time, it's not like they have a year, they've got a few days or week to complete that, whatever that discrepancy is. And it's already in the contract so that they won't close until that has been repaired.
We have two questions. The first one is, please differentiate between buyer representation and handling closing. Where is the line?
Okay. Do you want me to repeat that or? Okay. So where is the line, or what is the difference between handling the closing and buyer representation? They're basically the same thing. To be completely frank, us handling the closing is cheaper for the client than us doing a buyer representation, because when handling the closing, we are also obtaining funds from getting the owner's policy. So with a buyer's representation, we are not the escrow agent, so we are not handling any funds. I'm not collecting funds on the day of closing. I'm not sending out any proceed wires. I'm purely just the buyer's attorney. So on a typical transaction, on a resale, some attorneys will be on seller side, some will be on buyer side. If I'm not handling the closing on that one, it's the same thing. Just reviewing documents, being the buyer's counsel to ensure that they're feeling comfortable enough to sign documents, but I'm not actually funding the transaction. Whereas if I'm handling the closing, I am funding the transaction. I'm issuing owner's policy, any loan policy. If there's a loan involved, I'm doing that as opposed to not just representing.
Our second question was, what do you suggest for buyers who are from out of Florida who want to use their own local attorneys to represent them?
So first of all,
So the
that's a
question
very
is-
bad. Oh,
The
yeah,
question
sorry.
is,
I just
sorry, you might have seen me shake my head. What do you suggest for buyers who want to use out-of-state attorneys to review the documents? In my head, I just shook my head, really huge no, but she can tell you why.
Yeah, that's, first of all, unless they're licensed to practice in the state of Florida, they shouldn't be practicing law in the state of Florida. They shouldn't be reviewing a contract on behalf of Florida. As we've discussed, a lot of these contracts contain statutory requirements. A California or a New York attorney is not going to know Florida statutes. Same thing with even resale purchases, but especially for new construction, if they have somebody who's out of state that says, oh, I've looked at these several times, as a buyer's agent, strongly encourage them, maybe even put it in writing via email. I encourage you to reach out to and give 3 examples of attorneys that you might know in Sarasota, have them reach out and see that they can provide them the acceptable representation, because getting representation from an attorney that's not licensed in Florida, especially not even in this area. So many attorneys have really good relationships with developers here that we can kind of vet the developer right off the bat. I mean, the development company that Greg's working with, my firm has worked with them several times. We can instantly tell a buyer, your mind should be at ease. You don't have anything to worry about. All their projects are great. Whereas somebody in Tallahassee that practices Florida law, they probably have no idea. So using a good local attorney who can give personal feedback is the best way to go. I would do an absolute no to any representation outside of Florida.
Some of our most difficult contracts that we've worked with at the development I work for, Beso, have been from out of region, at least out of the area, or out of state attorneys that call in and say, hey, this contract doesn't look like anything like a New York contract. We want this, 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 and this. And you're like, well, it's not a New York contract. You're not a Florida attorney. And no. And, you know, there's just nothing that you can do. It's really difficult. You're not on the same language. You're not on the same page. It's a completely different thing. It's kind of like using an out-of-state lender for a condo in resale. For those of you who've done that and got caught up in that, you know that they wait to the last minute, and then you're scrambling around trying to save the deal on the date. And that's kind of the same thing with the attorney. You want somebody who's local, and like I said, vet your attorneys, make sure that they're good.
And then that kind of transcends into the next just discussion of when I am either one, just doing a contract review or representing a buyer or handling the closing. When I get that contract, there are very specific things that I'm instantly looking for, because I know that the buyers are going to have questions on those, and I want to get ahead of those to address everything that I can. And obviously in the market that we're in right now, it's crazy. I mean, people are lining up for lots. People are lining up for units. So the developers know, they're smart, that, you know, maybe some things that a couple years ago they would have agreed to amend, they aren't necessarily doing that now. So that's something that you as agents need to educate your buyers with too, because even if they bought something 4 years ago from the exact same developer, they might have been able to get that in 4 years ago because the developer was like, man, I really need to sell this project. Now, if they don't sell it to you, they're probably going to sell it to buyer B in the next couple of days. So just be mindful of that. And then secondly, like I said, the first thing I really do is I look who either the builder is or who the developer is, because I can get a pretty good read either from myself working with them or somebody else in my firm has worked with them. I can send an email, hey, what's your background on this? Have you worked with them? They're easy to work with. What do they allow? That right there, like Gregg was saying, is vetting your attorneys, making sure you're asking the right questions too, so that you're not giving your buyer off to somebody who maybe has handled one condo deal in the past 5 years. They're probably going to overcharge your client because they're going to have to spend significant time reviewing the contract, as opposed to somebody who's done 10, 15, 20 of these in the past 6 months. They know what the builder is going to go for. They know how to communicate, and they know exactly what to start going back and forth with. So going through contract, the first thing, and usually the most important thing for a buyer is the construction timeframes. So I always want to make sure that the contract provides for a definitive commencement date and a definitive completion date. And most of the contracts, again, they seem one-sided, but they're doing that because one, it rains all the time in Florida. Two, I mean, who would have known that COVID was going to come and create all these shortages? So they have these basically, notwithstanding any of the foregoing, the builder can change the closing date. So just, I have to educate buyers on that. You guys can do the same as well, that it's not like a typical resale condo or single family home where X is the closing date, you're definitely closing them.
It's kind of like the force majeure bit in the FAR bar and the as is, but it's rarely will a force majeure affect a resale, but in new construction, it's more likely to happen because that timeline you're talking about, you know, for a new condo, 2 to 2.5 years for a high-rise condo to be built, there's a lot more time for something to happen there.
But this isn't something you want to answer, but if in the chat, I'll reach out to you, but she said, this person said, you said it's an hourly rate to just review the contract, how do you price the buyer representation level? Is it a flat rate?
I will email that person separately. And then something else, there's a long list of these, so I'm not going to number them. I'm just going to keep going on what I look for in a contract review. Plans and specs. So I like to make sure that the buyer is aware of what if they change significantly? Are they still protected? What's the rights of the builder to change? And this right now, I'm talking more about single family homes, change orders as well. So what's the scope of the process and what's the process of getting a requested change order? So some more sophisticated builders require written change orders. There's a price to do so, and there's a very strict process. Whereas to maybe a mom and pop builder, you might just send them an email. There's no price to do it. Obviously, the upgrades are going to cost more money, but there's no actual price to do the change request. And then some builders are more lenient. Some builders are more stringent. It really just depends. Again, that's why it's important to have an attorney look through these contracts with your buyer so that they know what they're looking for and they can provide these answers to the buyer. And then financial contingency. So very few, I've seen one builder contract ever have a financial contingency clause in there. These contracts were drafted with no financial contingencies. They're expecting that everybody is going to pay cash, or they're going to figure it out prior to the closing date. The way around that a little bit is when the notice provision of a closing date. So some builder contracts will say 10 days. If I'm working with a buyer who's stating, you know, I'm going to get financing, I really would like 30 days. So then we can try to work with the builder to see if we can get maybe 30 or 45 days notice so that the buyer has 30 or 45 days notice to start their mortgage process. But it's a huge point that your buyers are aware of that very, very few condos, I would say none, just as an overall perspective, have financial contingencies. There is absolutely no loan approval like the standard contract, even if a builder does allow us to put some sort of 30 or 45 day notice in there, they're never going to allow for anything of if buyer doesn't get their loan, they get their deposit back. So that's a huge, huge difference in the contracts.
Do you feel like you have success with maybe shoring up or amending things, or do you feel that these builders do not want to make changes? I mean, what's this kind of customary? Like if I said, I don't want to wait 2 years to close or whatever, you know, I want that to say by this date before they do it.
So the question was, if I see that changes are received well, or builders just like, no, I'm not changing anything. About the completion date, that's something that they're rarely going to change because they know better than I do how long it's going to take for that project. The thing we can do is maybe put some sort of time frame that if it's after 60 days from the completion date that they're saying, then the buyer maybe has some sort of out, but that's pretty rare. But in regards to other things, most developers and most builders will give a little bit. It's very few that just are like outright no. But like I said, right now, if they want to say outright no, they can. But we almost always can get some sort of notice provision extended. And then we usually can get some sort of punch list put in there, which I'll go over that in a little bit. So I think they try to do the best that they can, getting to buyers' needs. I don't think at any point they're just like, no, I'm not doing anything. It is what it is. I think for the most part, they're pretty understanding for what they are getting at least.
So you on the selling side of it, of new construction, you don't want to have to resell something.
Right.
And the builders know that, hey, it's sold. So they may, even in this market, give a little bit to keep the deal together, but in this market, they're not going to give a whole lot. But they definitely don't want to have to go back and resell it. It's easier in this market for sure. There's some people that are demanding that they get something, and it's kind of outrageous. And we're like, okay, well, we'll sell it tomorrow and probably raise the price 20, 30,000 and sell it tomorrow just fine. So that's fine. Yeah.
And then the deposits I look at, we already touched on that. If it's a condo, I make sure that the buyer is very aware of the excess statutory language that's there. And then with single family home is the draw schedule. So that's probably the most time spent when going through a contract, is that the buyers need to understand and be made aware of the draw schedule. So usually on average 5 to 7 draws, depending. I'd say on most particularly it's 5, because you usually do 20, 40, 60, 80, 100. And if you're doing a construction loan, most of the time you're using the bank's schedule. The bank will be controlling when the draws are occurring, when the lien releases are occurring. But if you're working with a buyer who's paying cash, it's very prudent that they have an attorney, unless they've done this all the time, because they have to know to follow those draw schedules and get the funds in to the T, or else the builder can, not that they would necessarily, but they can start enacting some default provisions. So it's very important that the buyer is aware of the draw schedule, how it works. And then a title company, like I said, is involved too. Usually the escrow company, because they're making sure those lien releases and the title updates come in together. So getting a construction loan is a pretty in-depth process, and you need to be sure that they're working with the right people to make sure that it's going the right way it's supposed to. And then inspections, that's something else, kind of goes hand in hand with the draw schedule. Does a contract permit inspections as a condition to each draw? And then more importantly, as a condition to final payment. And then the punch list. So that's something that I touched upon a little bit. Most builders right off the bat don't have something about a punch list in their contract, but I think more frequently than not, they'll allow for it. And there's 2 things that we really try to touch base upon in a punch list, and that's the length of time and the monetary value. So if you're buying a $2 million new construction, whether it's a condo or a single family home, you don't want the buyer to be expected to close if there's $800,000 worth of work that still needs to be done. So we try to reduce that to maybe, all right, if there's anything more than $30,000, the buyer doesn't have to close until it's less than $30,000. And if it is less than that, they do have to close. So you put a threshold, so it gives the buyer peace of mind, and it gives the developer a peace of mind that they're still going to close, but it will also give the developer a time frame. So we might say within 45 days after closing, you have to have these remedied, and it needs to be brought under that threshold. Whereas opposed to if their punch list was not mentioned, it could be X amount of dollars. And there is some statutory time frame, but this hones in on exactly what deadlines your buyer is agreeable to and what deadlines the builder is agreeable to. So all parties are on the same page, because you don't want to get to 2 years down the road, you've finally been waiting for it to close, and then there's more issues where they're fighting back and forth. And then last thing that I really look at is the completion date or the closing date. Most contracts state that they need to give X amount number of days. I think 10 and 20 is probably the most frequent that I see. Again, that's something that typically most builders are not too worried about moving, whether it's 30 to 45. I think anything over 45 is a little bit too much of an ask, but and some might say, no, we're not getting more than 20, because again, they don't want any mortgage loans on there. They want people who are paying cash. So there's a little bit of risk in every real estate. But if you're paying mortgage, or if you're getting a loan with this, you know, you just have to be mindful that you might not necessarily have the full 30 days or 45 days. You're kind of at the hands of the builder with some of those things. So that's really all we have prepared. If anybody has any questions, feel free to ask, or if you want us to kind of hone in on any other areas where we maybe need to go into further detail, let us know.
So for the client just working with you on an hourly basis, not necessarily buyer representation, do they have to come to you prior to the contract being signed, or if there's an issue partially through construction, are you going to work with somebody at that point?
So the question was, if we're doing an hourly rate, do they need to come to me at the execution or prior to the execution of the contract, or can it be done mid-contract? The answer to that is we can help whenever. It doesn't matter if it's prior to execution, in execution, or during the contract. We can always help. We're never gonna turn somebody away unless we know we can't help. So always just give me a call or whoever you work with, and we can process that as it comes in. It's more of a case-by-case basis. But for the most part, something hourly is just going to be if somebody wants a contract to be reviewed. And each builder is a little bit different on an hourly basis too, just because I know how time intensive they may be. So sometimes just doing a buyer representation is more cost effective to the buyer, because once I'm in their pocket, it's a flat fee, and I'm in their pocket, they can ask me any sort of questions they want, as opposed to doing an hourly fee. Then, you know, the bill is just racking up, for lack of better words. So.
We have 2 questions online. First one is, can you give an example again on deposits for a condo purchase?
Oh, for a condo purchase, I can speak on BASO, for example. We have a condo deposit schedule of 10% down when you sign the purchase agreement. 90 days later, another 10%, and 180 days after signing, 5%. So you're into it for 25%. Now, some may do 20% deposit total, might be a 10 and 10 or a 10, 5 and 5. Others may do a 30% deposit schedule with a 10, 10, 10. Some people do it in a timeline like I gave, at purchase agreement, 90 days, 90 days, or it could be at the construction level. So at each point in the construction, say, when you break ground, or when you sign the agreement, you pay a 10% deposit. When they break ground, another 10%. And when they top the building off, another 10%. That could be done that way as well. One other thing I wanted to go back to the question, at what point in the contract stage would it be good to have an attorney look at it? I do want to remind you and let your buyers, your customers know that there is, by statute, a 15-day rescission period. So they can sign that contract and then go have an attorney take a look at it. And if they don't like it at the end, they can cancel for any reason during that rescission period. I've even had a cancellation that Mercury was in retrograde. So kind of a strange way to do it, but hey, any reason is any reason, right? So I just wanted to cover you on that. That's a good time to do it. Have them sign the contract. Don't let them sit there and look at it themselves. They'll just confuse themselves. Get them to sign it and then get it to the attorney of your choice or ones that you recommend, and let them choose their attorney and have them look at it. They have 15 days to do their due diligence.
All right, second question is, how much what do you suggest as to convincing buyers to secure an attorney when buying new construction?
I mean, I think all you can do, or do I need to repeat the question? How do you convince a new buyer to utilize an attorney throughout a new construction process? I think all you can do is advocate on their behalf and tell them, you know, I've heard horror stories of buyers who have felt unrepresented throughout closing, and it's just for them wanting to protect their investment. And for a buyer representation, it's not very expensive, and they can have an attorney in their corner to kind of coach them through everything. In regards to convincing, I think you can just tell them, this is what I would do if I were you. I'd always encourage my new buyers who are purchasing with new construction to at least discuss with an attorney of their choice. And after having an initial conversation or an initial consult, if you don't want to go that route, you don't have to. I don't charge any sort of initial consult fee. I know my firm does not. And I don't think too many real estate attorneys do. If you just have a buyer who wants to call and ask a quick question of, hey, have you worked with this developer before? What are your thoughts? I mean, if we're not the type of attorneys that start immediately pushing a time clock and billing. That's not the nature of the business we're in. So maybe that would be an easy way to quote unquote convince, is to just say, hey, why don't you just give one of these three a call, or give an attorney of your choice a call and just discuss it with them and see how they feel. My guess would be more often than not, they'll end up going through with having an attorney represent them, just because the attorney is going to give them peace of mind that they'll really protect them and show them what they can offer. And for the cost benefit analysis, that's probably going to do the convincing for you on that part.
Greg, a question for you. At Bezo, are they cash only sales?
Yes, it's a cash only contract. Now, there is an option for lending that's, all of them have the lending option, but you can get the lending beforehand. As long as you're bringing cash to the table, that's what's needed. So we do have a number of buyers in Bezo that have asked us, who were lenders that you would recommend. We do have a few that are, and if they want that information, I can give it to them offline. But yeah, we have a handful of people that we do know that will be going out and getting lending beforehand, but they'll be bringing the cash to the table.
A little bit similar, but if we're working on a seller side like you are and we're finding a builder or developer, how do we sell you to help you do that, first of all, to help them build contracts and protect them on, like, let's say they're a smaller builder who is getting started in our state and they came from out of state or something like that, and we say, okay, we want you to use an attorney to help, this is who we suggest, but what would be a good way of like differentiating and saying, okay, use them because X, Y, and Z?
So I think your question is, do we do developer work as well?
Yes.
So yes, so we do. We do a lot of developer work. Jamie Ebling, one of our partners, has done a lot of it. I'm doing my first development project right now with a builder. So I think we could kind of show our track record of how many projects we successfully started from the ground up. And they could kind of vet through there. I know there's other firms in Sarasota have done development projects as well. I think our firm, obviously I'm a little biased, I think we have the best reputation for doing developer work, but that's definitely something that we do. That's a very in-depth process because we have to go through the statutes and the admin code to ensure that everything is compliant, because if we kick it to the state and if it's wrong, they automatically send it back. We have to do everything again. So when you're working with a developer, you get it right the first time, or they're going to go find somebody else who can do it right for the first time for them. So we are very knowledgeable on doing that. It's going to be a case-by-case basis on price-wise, though, depending on how large the development project is or will be. That answers the question.
Can you please state the 3 kinds of warranties that come with new construction of single-family homes and condos?
So the question is, can we state the 3 types of warranties that come with single-family homes and condos? I can definitely speak on the condos. You do have a 1-year warranty on the interior, your residence in the condo, which is, drywall to drywall or paint to paint. Anything on that, there's a 1-year warranty. Your appliances will most likely have a 2-year warranty, but that's based on the manufacturer and the date that they were manufactured. Then you also have a 3-year building warranty, and that's for the building structure itself. And then there's a 10-year latent warranty, and those are hidden. Those are warranties for parts of the building that you can't visually see without getting special equipment into the structure. So those are the three types in condo, probably relatively similar in single family home, with the interior being a 1-year warranty, even structural. There might be a 3-year for the structure, but probably not. And then you've got your just drew a blank on the word. It is such a simple word. Your refrigerator and your appliances. Oh, good Lord. I was in big and then I had to go small. And so, yeah, appliances, you'll have your 2-year warranties with those as well. So.
Someone asked, have you noticed that there are certain things missing from most new construction contracts that you'd like to amend?
Just because I've reviewed so the question was, how do I know if something is missing? I think over the course of my career, I've probably reviewed close to 100 of them. So I can tell what is missing and what's not missing pretty quickly now. I can tell also if it's a 4-page contract, it's missing a lot. If it's a 35-page contract, it's probably not missing very much. That's just going to be more of tweaking it to the buyer's needs and wants at that time. But that's just kind of, the longer you're in practice, the quicker you can pick something up.
Next question, I don't know if you can answer. I know you could speak to your own development, but I don't know about this. Is there any cancellation period for single family homes such with condos?
So any new construction, the question is there any cancellation with single family homes? I mentioned that 15-day rescission period in the condos, but that applies to all new construction that is developer new construction. Now, if you went out and hired your own contractor to build for you a single family, a custom home, that might be different. But when you're talking about developments, those there is a 15-day rescission period, no matter what kind of development it is.
All right. What are the legalities in marketing new construction developments? For example, if you want to market a Lennar home, but it isn't your listing.
I don't personally know the answer to that. I know all of the advertising has to be statutorily compliant on the condo side. I don't know as an agent what the ethical obligations are of marketing a listing that's not necessarily yours. I think I would say no, but I'm not too sure.
So let's look at it this way: in resale real estate, if you've got a home that you've got listed and somebody within your brokerage comes to you and asks permission, everyone should be asking permission to market your listing, right? So you've got somebody that comes to you and says, hey, I'd really like to market your listing. Can I do that? Of course, you're going to say yes 99% of the time. When it comes to doing something for a developer, the developer probably has some unbranded marketing material. I know we have that at BASO. We have unbranded material. We want you to market our condo because the more people that get eyes on that beautiful building, the more people are going to come, and Lennar is probably no different. Now, if it is a building if it's a Lennar build that they are building and that buyer has not taken possession but wants to market it to sell it for when they take possession, that I would probably recommend not touching, because the buyer doesn't own or possess that building in order to sell it, to give to an agent to market it.
Do you communicate directly with buyers, builders, developers when handling a closing, or is the info passed to the agent to pass to the builder developer?
I handle the communication. So any attorney who is handling the closing or acting as a representative of that buyer, we are speaking, and usually it's via email or sometimes phone calls. We're copying the agent so they're aware of what's going on, but we're definitely not acting as the agent is a funnel. We're not saying, hey, I got this information, now you pass it on. We're trying to make your jobs easier, not create additional work for you. So we'll copy you on everything, give you a phone call if it needs to be discussed over the phone, but we are communicating directly with either the reps at the development company, the closing coordinator at the development company. We're doing that communication for your buyer and for you as well, but making sure you're understanding and in the know of what's going on. So we don't go to the agent and say, okay, I did this, now it's your turn.
Long one for you.
Okay.
With all of the delays in construction lately related to COVID, material shortages, and labor delays, is there some recourse to a buyer if the builder is unable to complete the project after a certain amount of time has elapsed? I remember reading something about 2 years on a contract at some point. Is that correct?
So the question was, is there any sort of out for a buyer because due to the shortages nationwide of materials, is the buyer protected? It depends on the contract. So some contracts, like I said, they might have that 60-day window. More often than not, I think they're still going to be stuck in that contract. And if the buyer is so close to completion, are they really going to go lose their dream home over 4 more months? Or I know it's very unpopular opinion, but right now I don't think there's any sort of in-depth always protection for the buyer with the current way the contracts are usually drafted, unless there is some sort of additional period that an attorney can amend or that the developer had in their contract from the get-go. I don't know if Gregg has anything to add.
Yeah, I'll say this. So when you're buying new construction, let's say for a high-rise condo, right? And it's going to be a 2.5 year build. And the buyer is getting a discounted price because they're willing to make that investment. They're willing to take a risk into buying something that's going to be completed, hopefully on time. The developer wants to finish that building on time. They don't want to lollygag and spread that out. They've got skin in the game as well. They're taking the risk of a financial risk to build the building. So, and the bank is taking a risk on both the developer and the buyer, that there's enough buyers in there to put the lending in. So they're not out there to spread that build out as long as possible. They want to get it built. They want to build it well and safely and with as much quality as possible for that buyer to take advantage of that early pricing if they buy in early. If it doesn't finish on time, the chances are that it was the builder's fault, the developer's fault is very, very slim. It's most likely going to be one of those force majeures, those acts of God, hurricanes, COVID, shortages. We are seeing the shortages are going away. That supply chain is starting to come back to normal. So that shouldn't be, we shouldn't see that happen unless we do have another supply chain issue. But that supply chain is starting to bounce back. I hope that answered your question there.
Yes. Do you foresee changes in condo laws coming as a result of the condo collapse and Surfside, especially in regards to reserves?
Okay, so the question is, do we see any changes in condo laws because of the Surfside condo collapse? I will say this, that there are statutes, that there are building codes that change almost yearly that make it even safer to build. And the buildings that are being built now have to follow those codes. If you look back on that Surfside situation, you know, in 1991, 10 years after that latent warranty wore out, they found out that they had a lot of problems. And depending on how that HOA was structured, it was structured probably with a 100% vote of the residents and not letting the board take control of it. They kicked that can down the road over and over again to pass those costs of repair off to the next owners. And they waited too long. So really needed, it's more of an HOA situation, I think, that probably need to be changed than the building code or laws for condos, because that, the building, there's so many layers of inspections as it happens, and building is so much better than it was 40 years ago. I just don't see that happening. It was a very unfortunate incident that happened down there at Surfside, but I don't see them changing laws necessarily.
That was the last of the questions that Zoom had for you. Anybody else in the room have any more? All right, well, I think we can go ahead and conclude this session. Thank you both so much for being here today. We really appreciate it.
Thank you guys.